Recording in progress.
Okay, great. All right, so welcome to the estate planning session. It should be a wonderful hour of really good information. So I'm going to jump right in by sharing my screen, and we will get going. Okay, so although this tonight is not about designing your joyful retirement, but part of being able to have peace of mind in your retirement is knowing that you've got everything in order. So I'm Pauline Field, I'm retired and I'm working, and there's a whole lot to think about for a happy retirement. And today we're talking about estate planning. So the biggest questions are, of course, about wills and trusts. You know, why do I need them? How often do I need to update them? Do I need a trust as well as a will? And so on. These are the kind of questions we'll be talking to. And then what other things I need to be taken care of now rather than later? And here, to answer the questions, is Camden DeLong. He is the managing attorney at Generations Law. And to tell you a little bit about him, he's a Southern California native. He lives in Long Beach with his wife, Anna, who owns and operates a neighborhood wellness center. They go to bed early, wake up early, and get along well with each other and everyone else. And I'm not surprised to hear that because he's just a charming person. Camden graduated law school and passed the California bar in 2011. He's in the estate planning business because he wants to help people avoid the type of drama that is completely preventable. For me, estate planning is not really about planning for death, Camden says. It's more about helping people live in a way that is organized and responsible when they're vibrant and healthy. Then, when life throws us the inevitable curveball, we can refer to a plan. And that plan should help family and loved ones avoid the drama, going to court, who should make decisions, fighting over money, etc., etc., all of which was preventable. So I'm going to stop sharing my screen and we'll jump right in. And by the way, Karen and Cindy, as you're here, anytime you have a question, you can just wave your hand, you can put it in the chat, whatever you feel comfortable with, because we want to answer all of your questions too. So I have done a little introduction, Camden, but you know, I've had the pleasure of meeting you, but the others on the call haven't. So tell us a little bit about yourself, a little bit more, and how you came to be in this field.
Yeah, I'm happy to, and thanks for having me, Pauline, and nice to meet you, Karen, and someone just dropped off.
Oh,
but anyway,
well, maybe Cindy will come back. Yes.
Yeah, Cindy. So yeah, the reason I'm in this business, I was thinking about this the other day. So, and it might not be relevant, but basically when I was in my teenage years, my mom and dad went through a nasty divorce. And then my mom wouldn't take my dad back because he was a naughty guy, right? He was what's the word? He was unfaithful in the marriage. My mom would take him back, so they got a divorce. And my dad was trying to hide assets from my mom so as not to give them to my mom in the divorce, which is like crazy, but anyway, probably illegal even. But way he thought he should do that is to transfer assets into the name of his girlfriend at the time. And then he literally died. And so his assets went to his girlfriend. And I literally, I don't think I've told that story in public before,
Uh,
but it really was like a traumatic, and I was one of 5 kids. And so like my dad, even though I was 16 at the time, like the fact that my dad was a smart, successful guy and that he didn't leave anything for his 5 kids, that would have made him really sad, I think. But also his actions showed that he was kind of like willing to roll the dice as to that not happening. So at the end of the day, I don't really know. So I think like deep down, I'm like, man, a little bit of good planning would have probably saved a lot of BS and drama. And so really, I think fundamentally, I want to help people avoid making kind of like shitty, just like impulsive decisions about, you know, these types of things. I really think that that's what it comes down to.
That's great. Thanks for sharing that.
Yeah.
Because that makes it very relatable. That I'm sure you're not the only, or your parents aren't the only ones who went through a nasty divorce,
Right.
and your father's not the only one who tried to hide assets. It's like
Right.
these are, unfortunately, they're common occurrences. So whether we have the same occurrences or something similar, it informs us that there are things we can do.
Yeah.
So because of my clients and the people who are watching this both live and after the fact, let's begin with a basic question. What is involved in estate planning? I gather it's a whole lot more than just drawing up a will.
Yeah. Your basic estate plan in California will include a living trust. It will also include that will that you just mentioned. And I'll kind of go through each and tell and explain why each is necessary. But it's a living trust which can be changed during your lifetime. So once you create a living trust, it's not set in stone. Living trust, there's a will, there is a power of attorney for financial decisions, which gives someone else the power to make financial decisions, banking decisions, pay your tax bills, etc., if you are alive but unable to act in your own best interest. So if you're incapacitated. And then there's a healthcare power of attorney, which is known as the Advanced Healthcare Directive, which authorizes someone to act in your stead for healthcare decisions. And then on top of that, if you own real estate, you would have a deed transferring your real estate from yourself into your trust. And there's a couple of other ancillary documents, but those are the core ones: a living trust, will, power of attorney for finances, power of attorney for healthcare, and then the vesting. You got to make sure the assets you're putting in your trust are vested properly.
Yeah, that's very good. Thank you. So, some of my clients have told me that they do have a will. So they checked that box and thought nothing more about it. So how often should we redo our will? And does it have to be very complicated? How do we determine what we should leave to whom, for instance?
Yeah, that's a good question. So as far as a will goes, if you just, I kind of rank someone's preparedness based on what they have in place. So the basic estate plan that I just described, which is a trust and a will and powers of attorney, that is basic yet comprehensive. So that's like a good level. You're in good shape. if you have a will only, you are in better shape than having nothing at all. But your will without a trust goes through probate court. So your will can be valid for decades. So if you executed a will today and then your you have another 40 years or 50 years of life expectancy, as long as the will was witnessed properly and is executed properly, you can say in there, I want 50% of my stuff to go to my son and 50% of my stuff to go to my daughter. This is my personal representative. And that will could actually be valid 50 years from now. Now, if your son no longer exists or it turns out that he is not good with money, or he got divorced, or he's in a relationship with a very tumultuous partner or something like that, you probably don't want to leave it up to chance. And you might want to revise your will, or not even revise it. You would revoke the will and create a new will. But so I guess to answer your question, if everything is status quo from the date that you make your will, technically you don't have to change it. But having said that, every year that goes by, and a life situation changes, or we're going to be relying on the will quite a bit, and it's going to be going through probate court, the older it is, the more someone is likely to find a fault in it. And that goes also with something, if you'll allow me to kind of expand on that question, but apply the reasoning to a power of attorney. So if you have a power of attorney that you execute today, and that power of attorney doesn't come into play for 30 years, that is not good. That's not a fresh power of attorney. That means that decades ago, you nominated person X to act for you with respect to financial decisions, but that does not breed confidence in the institution. Chase Bank isn't going to be like, oh, okay, great. Here's a 30-year-old power of attorney. I'm going to give access to the bank accounts to this, based on this 30-year-old document. It doesn't breed confidence. So trying to balance my answer between, you don't need to update stuff all the time, but you don't want stuff to be stale. And so usually if we're keeping track of what our preferences are and what our family situation is, and it's changing over time, you'll probably want to just look at stuff every 3 to 5, maybe every 3 years, 3 to 5 years, and just say, hey, is the person I nominated to act in my stead still the person that should be acting in my stead? If the answer is yes, then perhaps nothing is needed. But if the answer is, well, I don't know, they moved back to England, maybe that person isn't the best choice to be making healthcare decisions for you if you're living in Seal Beach, for example.
Right. So you can either look at it as every few years, or if something happens in your, if there's milestones in your life, right?
Exactly.
Like if you get a divorce, if you get remarried.
Totally.
Yes.
Yeah. So big life, yes, life change, or not life changes, but yes, life events,
yes.
family additions. Is that person's relationship going pretty well? Are we confident that that person is making responsible decisions? Stuff like that. And yes, so to your point, you're spot on with that. Yes.
Okay.
Mm-hmm.
So, like so many of us, we hear stories of families fighting over their parents' estate, and how unpleasant and upsetting that can be. Mm-hmm. Have you found anything in the process that can cut that off before it even happens?
The single best way to minimize the chance of family infighting is to not to die with stuff in your personal name. You want to have stuff titled into the name of your trust, or you want, for example, bank accounts to have beneficiary designations or 401k accounts to have beneficiary designations. Most any asset can be, you can add a transfer on death or payable on death beneficiary. That's kind of like the DIY estate planning. Those type of assets avoid probate. So if you have a bank account with 75 grand in it and you have your spouse or a son or daughter listed as a payable on death beneficiary, the bank only needs to see a death certificate. That money goes straight to the person. There's no challenge. There's no fighting. I mean, that's not to say that the siblings aren't going to squabble after the fact, but at least there's really no legal challenge to that kind of stuff unless there was undue influence or fraud or something like that. So the single best way to avoid that family fighting stuff is to avoid probate. It's to avoid having your estate have to go through probate court. Because if you die, and I hate to make it all about death, but if someone passes away with a $100,000 Chase bank account and they don't have someone else, another joint person on that account, they don't have a transfer on death beneficiary associated with that account, that bank account goes to probate, even if there's a will. And that's when the probate judge says, hey, daughter who filed the probate petition, yes, I'm going to name you as the executor or personal administrator of your late mother's estate. And based on the fact that there are 3 kids, we're going to split this $100,000 Chase account 1/3, 1/3, 1/3. And I probably should have, in this example, if there literally was only $100,000, that would avoid probate, because you don't have to do probate unless assets are more than, I think, 150 grand right now at current law. But I'm assuming that there's a bank account, there's a house, there's some family heirlooms, there's some furniture. If the estate in total is above 150-ish grand or 160 grand, then the probate, this whole court process happens, and that's when the kids, that's when the family infighting really starts, because the deceased never said what she wanted to have happen.
Yeah, got it.
Mm-hmm.
So now, you talked about a living trust.
Yes.
So what does a trust do that a will doesn't do in helping to distribute the assets after someone dies?
Yeah, that's a super good question. The common thought is, write a will and that will direct what happens to my stuff. And that in California is not the case necessarily. Your will still has to go through probate court. You still have, there's notice to all of your kids and family. Anyone can come challenge it. It's super expensive and time consuming. The difference with a trust is that any assets that are held in a trust are not subject to probate court. So if you have a trust and you have a piece of real estate worth 500 grand, 120,000 in your Chase checking account, and a $250,000 investment account or something like that, and those things are properly held in your trust, and you say, as long as I'm alive, I am the beneficiary of all of this stuff in my own trust. But if something were to happen to me, then I nominate person X to distribute my house, my bank account, and my investment account to my nephew and my granddaughter, or however the hell anyone wants to do it. That avoids probate. You don't have to go to a judge to sign off on your documents. You don't have to have a long drawn out process. If the process is so that process is called the trust administration, where you're just administering the trust. And the other process in probate, that's called a probate administration. The trust administration is significantly less costly and less conflicting, or it's less likely to have family infighting if you have a trust and you're not subject to probate.
Let me ask you this:
Yeah.
If there are, maybe several children involved, and although somebody has a living trust and they have a will, and they need to name the executor, is it better to pick a friend or a family member, or to pick an attorney or somebody from a bank, or what's your recommendation?
Yeah, that's a super good question. That's a really good question. I always say, or my genuine opinion on this is, all of the trusts I write have very specific provisions that say any acting trustee is empowered to employ the proper professionals in the duties of their job as trustee. So my thinking is that as long as the person is competent and the person has the family's best interest in mind, they're a very good candidate as trustee. When we're talking about corporate fiduciaries and bank trustees and corporate trustees, also called professional fiduciaries, they can be fine, especially in the case of a larger estate, and especially in the case that the beneficiaries are unlikely to see eye to eye. If you don't want to put a family member through the ringer, as far as, because I mean, that can be a job depending on how the trust is structured. If the trusts go on for, until the kids reach 50, then obviously the trustee has their work cut out for them. So in the case where it's going to be a long trust administration, or there are sub trusts within the main trust, and there's a likelihood that people aren't going to get along, a bank or trust company works well. They're a lot more expensive, a lot less flexible. They're a lot more likely to be like super by the book. And even if beneficiaries agreed to something, a trustee like that might be like, well, my hands are tied. I can only do what the document says, that type of thing. And so for modest estates with modest complexities, I would say just someone who has the family's best interest in mind, who's competent, is perfectly fine.
Great. Yeah, that's good to know.
Mm-hmm.
One thing I think we can all agree on is that we'd rather pay less taxes than more.
Mm-hmm.
So can you talk a bit about estate taxes and who will pay them?
Yes. Estate taxes, the estate and gift tax rate is currently 40% or so. So if you're subject to estate or gift tax, that's the rate. It's high estate and gift tax. But estate and gift taxes don't come into play unless you are at this point ultra high net worth. So you can, as a married couple, you can leave, let's just say leave and give to people to inherit, or you can look at it, that's why they call it the estate and gift tax. It's like they're kind of two sides of the same coin. During your life, you can give away as a married couple $25 million without paying estate and gift tax. As an individual person, you can give away $12.5 million, give or take, during your life without paying estate and gift tax. Each year, I don't want to get into the weeds. So that is the gift tax portion. I can give $12.5 million throughout my life. And that means that if I were to give my brother $1 million today, just straight up give him $1 million, then my lifetime exclusion of $12.5 million now bumps down to an $11.5 million. So I've given away $1 million of my lifetime exclusion of 12.5. And so I have to file a little gift tax return, tell the IRS, hey, tax man, I've given $1 million away. No taxes is due on that because I still have 11.5 million now in my lifetime exclusion. So I'm like keeping track over my life. So then when it comes to the end of my life, I can give 12.5 million away before the estate tax kicks in. So say I didn't give anything away during my life, and I give it all away at my death through my trust. As long as I'm below the 12.5 million or whatever I did during my life, then I can leave that amount tax free. So most people, I find, the vast majority of my clients, they're making, they'll give their kid a $12,000 car, and that's neither here nor there. They're probably not filing. They don't even need to file a gift tax return on that. But they have not chipped away and gobbled up their lifetime estate and gift tax exclusion. So basically, they're just now worried about, all right, I'm 88. I'm going to leave $3 million to my daughter and $3 million to my son. That's $6 million total. That's well within the lifetime exemption. Therefore, it's estate and gift tax free. So that's where we're at right now.
Yeah.
On January 1st of 2026, the estate and gift tax really high lifetime exclusion amounts that are currently at 12.5 million per person, those are set to come down. They're expiring. Those high exclusion amounts are set to come back down to, I don't know, $4 or $5 million per person, which is still pretty high. But the trend is that rich people shouldn't be able to leave that amount of wealth to their next generation tax-free. That's what the current administration is kind of signaling, right? And so unless Congress extends these really high caps, those high caps are going to come down. Still not going to affect that many people, because if I can leave 4 million or 5 million and my wife can leave 4 or 5 million, we can still leave 10 million. That's a lot of money. But it's going to dragnet a bunch more people in than currently is the case. into estate and gift tax. So with all that being said, most people want to avoid estate and gift taxes. There's a couple major ways to do it. One is you give stuff away in small pieces during your life. You can give stuff away up to a certain amount per year that doesn't count towards your lifetime cap. So if I'm giving 15 grand to my grandson, 15 grand to my granddaughter, 15 grand to my daughter, 15 grand to my son, 15 grand to my nephew, blah, 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 all under the yearly annual exclusion amount. That I can do for years and years and years and decades and decades and decades, and that doesn't gobble up my high lifetime exemption. That's one way to do it. Little sprinkling things here and there. Another way to do it is if you're giving charitably and if you're like, hey, I have, money, I know for sure that I'm going to give 50 grand to the Friends of Long Beach animal shelters and 50,000 to the Red Cross, or I want, some money, then that type of giving, the charitable giving, doesn't count towards eating away at your high lifetime exclusions. But it's basically just giving stuff away in a way that doesn't, if you're in that bracket that might be subject to estate and gift tax, it's giving stuff away in a way that won't gobble up your lifetime exemption, if that makes sense. It's like estate tax planning is like, it gets nuanced, to say the least.
Yeah. So, you brought up charitable giving. So whether it's to your kids or other members of the family or to charities, or it all comes under the same thing of gift giving?
There are many subspecies of gift giving, but for example, if someone had like, I don't know, I maybe want to say an actual asset that is income producing. And let's say it's an apartment complex or something like that. You could give that apartment building to an irrevocable trust. So we were talking about revocable trust, which are, I can change this during my life. I still have full control over all of the assets in my living trust. That is a revocable trust. It's a much more basic, straightforward, I manage my own trust, I'm the beneficiary of my own trust, and I'm saying what happens to my stuff in the trust when I die. The irrevocable trust is someone's, it's their irrevocable and permanent giving away of something. So then that something is no longer in my estate. So that's no longer going to count towards going to be subject to estate tax if I die. And not only that, I can give this apartment building to an irrevocable trust, and the income from that apartment complex can go to my grandkids or my kids or whatever, but on their death, it goes to the Catholic Diocese of Seal Beach. That would be considered like, and I'm paraphrasing, but that's a higher level estate tax move where you are ultimately giving this apartment building to charity. And so therefore it doesn't count against my gift tax exclusion amount. It's not gobbling up my $12.5 million gift tax exclusion, even though it's giving income to my family while they live. And then when they die, it goes to the church. So it's kind of like a hybrid of I'm definitely giving it away, but it's going to benefit my family for a while before it goes to the Catholic Church. So that's higher level stuff that we don't really do that type of planning in my office, just a heads up. That's for people that are worth, like 20 plus million and they're very tax averse or very charitably inclined. It's kind of like, I don't know, some people are very tax averse, some people are very charitably inclined. So kind of depends where they're at.
Right, right. Um, you, you said earlier that estate planning also includes, the healthcare directives.
Yeah.
Can you say a little more about that?
Yes, totally. So, I mean, I don't know if you all have been in this situation, but I have, where I've had grandparents be, they basically they phase from living on their own to living in assisted living to now we're living in a nursing home. And it's super important for them to have had the healthcare powers of attorney, also known as the Advanced Healthcare Directive, which also include within those, it's called a HIPAA authorization, which gives, like in this case, let's just say it's my grandma. It gives the hospital the permission to release my grandma's health records to me, or it gives the hospital permission to release my grandma's health records to her nursing home, so that there's all these privacy laws and there's all of this red tape. And if you don't have these basic healthcare directives and financial powers of attorney, I just group them under the powers of attorney. If you don't have those in place, I mean, once somebody is diagnosed or I don't want to call it deemed incompetent, because that's like a very, yeah, there's legal definitions for this stuff. But once someone is incapacitated, that doesn't mean they're in a coma and because they got in a car crash, although that would apply too. This means like someone had a stroke and they're literally like aren't thinking clearly and they can't contract. They're like legally they're legally incompetent. So anything they sign is invalid, and so they need someone to be looking out for their best interests in the healthcare context and in the financial context. And I think that people, I'm glad you brought it up, because I don't even do, if someone comes to me and says, hey, I just want a will, I just, I talk to them, try to educate them, but that is incomplete. It's an incomplete plan without the healthcare power of attorney, HIPAA authorization, and financial power of attorney. It doesn't do anyone any good.
Right, right.
Yeah. Because that will come into play eventually, unfortunately, but it will.
Yeah.
Yeah.
All right, before I go to more of the questions that I have,
Sure.
I want to see if Karen or Cindy have any questions.
Sure.
Yes, I have a question. Okay, we have a trust.
Okay.
And I've updated it once, but after hearing you, I feel like, okay, I need to review it again. But I don't recall if we have a will. I mean, if we don't have a will, the trust is still valid, right? Or do we
the trust is,
will too?
yep. Trust is still valid. And usually, if you have a trust-based plan, which I highly recommend, the will that is part of your estate plan is called a pour-over will, and it acts as a backstop. And it says, I, Karen, nominate my sister or my husband or whomever to be my personal representative in the event that one should be named for me. And the personal representative is authorized to gather all of my my assets or my things that I obviously intended to pass via the terms of the trust. And I authorize my personal representative to pour all the stuff into the trust. So then your trust it says what happens to your stuff. So the will that complements the trust is called a pour over will.
Pour over well. Okay.
Yeah. And I would bet, or I would hope that you have a pour over will as part of your estate planning docs if you had a trust.
Okay. I need to look at it again.
Yeah.
Also, you mentioned what was it? I was going to say oh, I have because I just retired from education, and I have what we call 403Bs, which is a little different than similar to 401k.
Yes.
I know I have listed as my husband as beneficiary,
Okay.
but should I put that in the trust as well? But I'll because I have like 3 of them.
Yeah. The tax deferred retirement accounts are not retitled in the name of the trust. So you're not changing the beneficiary designation of the 403B. I like that you have your husband as listed as the beneficiary. Sometimes I would recommend to list do you have kids?
Yes.
Would you want them to inherit if your husband wasn't unable to, or no?
Well, yeah, so because I have them listed on my checking account, my bank accounts.
Okay.
I have them all listed there, and the thing of it is, like, because I have my niece as our the
Successor trustee.
yes, the trustee, and and yeah, see, I don't know if I should change that or not.
Okay. Well, as far as the 403B, 401ks, IRAs, I recommend you name a human person as the primary beneficiary of those plans.
Okay.
I recommend as a successor, if your husband were not able to inherit, I would think about naming the person or people that you would want the money to go to anyway. And then as a fallback, I would name the trust as kind of like contingent beneficiary. So those tax deferred plans, there's never going to not be a beneficiary, but because of the required minimum distribution rules that these tax deferred accounts are subject to, it's good to go to direct family. And if your trust is going to be paid, your trust should have specific provisions to accept those proceeds and then distribute them accordingly. So the tax deferred plans, human people, but if you say, like, yes, my husband, but if he's not around, I really don't want this stuff to go to my kids, then you obviously, you don't, name someone else, or just name the trust if your trust has alternative beneficiary designations.
Yeah, I just filled something out the other day for, I think it was the pension I'm going to get. So Greg first, and then I put the trust second.
Yeah.
That's what I did. I just did that like last week.
Okay. Yeah.
So that's okay then?
Yeah. Yeah. Pension stuff is, wait, did you say it's going to you and then?
Well, like if something happens to me, Greg gets a portion of it. And if something happens,
Automatically, right? Like a survivor's benefit.
exactly.
Right.
And so if something happens to Greg, then it goes to the trust.
Yeah, that's fine.
Okay.
Yeah.
Okay, great. Cindy.
Yeah, I have a couple questions. Can you explain again the trust administration?
Yes. So I created trust with my wife. We have a house. I put the house into our trust. We end up having 2 kids over the next couple years, and we just want our stuff to go 50-50 to our kids. Upon my death, my wife is just now the successor trustee. She's also the beneficiary during her life. Now, if something happens to my wife, now I guess the successor trustee, the person that we name to be responsible for making sure our assets go to our kids, now has to do something called a trust administration. So they have to go in and they have to say, all right, the trust owns this piece of real estate. Okay, so now I got to go hire I have to tell Camden's kids in writing, hey, Camden and Anna died. They had a trust. You are named as the beneficiary of the trust. If you want a copy of the trust, please write me at this address. There's like a formal notice called notice by trustee that you have to give to beneficiaries. That's part of the trust administration process. But the real trust administration is now I have to liquidate the trust assets and disperse them per the terms of the trust. And so basically like hire a realtor, have them sell the house, split the proceeds between Camden and Anna's kids. There's a bank account that was in the trust. Give the bank the death certificate, show them the terms of the trust, get the money, give them to the kids, contact the Camden and Anna's accountant, tell them that they died, have the accountant file a death tax return for the trust. Just kind of like winding up the affairs. That's what a trust administration really is.
But if your kids are adults, can you give that responsibility to one of the kids? Do you need to have a trust administrator?
You don't. No one needs a trust administrator. If it's straightforward, the trustee themselves will administer the trust. It's only when the trustee is kind of in a pickle or there's complicated stuff going on that the trustee is going to hire a lawyer to help them with the trust administration process. In the situation I just described, depending on how up to date I left my trust, if my kids are responsible and cool, what I would have done is named them as the 50-50 beneficiaries of the trust, but I would also have named them co-successor trustees so that when Anna and I die, the kids themselves administer the trust for their own benefit. And I mean,
but I missed that one word. Full. Did you say full trustees, or what was that word?
Oh, I'm sorry. I said I would have nominated them as co-trustees.
Co-trustees. Okay, right.
And so we would just say, hey, little Sally and Johnny are co-trustees, and they can make decisions for their own benefit because really that's who we left the stuff to. And in that sense, no, they don't need to hire a lawyer. As long as they're savvy, they can hire a realtor or for sale by owner for all I care.
Right. So you don't need necessarily a trust administrator if your kids are capable of doing it.
No, you don't, but keep in mind that they are administering the trust. So they are self-administering the trust. So they're not hiring a lawyer to help them with trust administration, but they are doing trust administration.
But and they can if they want to.
Oh yeah.
Yeah. Okay.
Yeah, they totally can.
Okay. And then I just have a little will before I had some surgery,
Okay.
put together some stuff. But what will putting together the will and the trust a little bit more concretely, how much is that going to cost me about?
What's your situation? Are you married?
Yes.
How many do you have kids?
Two, 125 and 128.
Are you in your first marriage?
Yes.
Okay. Do you guys own real estate?
A house.
Okay. Whereabouts do you live?
Pasadena.
Okay. And any family issues are pretty straightforward.
No.
Okay.
No, and both of my sons are, well educated.
Okay.
And
And then
one's in finance. So
okay, that's cool. And then are you and your husband both retired?
I am, he is sort of, not
Okay.
officially, not officially.
And then is your guys's net worth below like 3 million bucks?
Definitely.
Okay. In that case, I'm gonna quote you a price or a ballpark. But I do want to say a couple things first. All right. The first thing is that I specialize in super fast and super easy estate planning. So you don't have to come to the lawyer's office and you don't need to do anything. Basically, you would have a 30-minute Zoom call with me, and your husband and you would have a 30-minute Zoom call. I would get your information. I would design your plan. And then a week later, I would come to your guys' house in Pasadena with my notary, and we would execute everything with the notary. And then my notary has a scanner, and they scan all the executed documents. They upload it onto a USB drive. We give you your physical binder and digital copies at your kitchen table, and then we leave. So there's literally like all of the legwork that all the lawyers want you to do is done for you. And so I just wanted to let you know that that is included in my price. But it would be $3,500 to do what we're talking about: living trust, 2 wills, 2 powers of attorney for healthcare, 2 powers of attorney for finance, a deed putting your house into your trust, personal property memos, assignment of personal property, all the ancillary documents we talked about, $3,500.
Okay. And is that's ballpark of, if I, shopped around, that's what it would be about?
You can do this on your own on LegalZoom for probably $1,500. You can find lawyers that would charge you $7,500. If you shopped around, I could save you a ton of time. I'm definitely not the cheapest. The reason people hire me and my firm is because they don't want to coordinate schedules. They're not going to take half the day off to go to the lawyer's office. They're not going to fill out a 20-page questionnaire about their life story, about their bank accounts and all that BS. I literally, like, you're paying for speed and convenience by working with my firm. But yeah, we're definitely not the cheapest, but we're definitely not the most expensive. Yeah. But
And
you'll
do you do
find, yeah, go ahead.
updates? Do you do updates?
Yeah.
Like if I want to change something in the will or whatever, is there a fee for that?
Yeah, you can't update a will. So you would need, if you want to change your will significantly, you would just do a whole new will. And so,
I'm,
yeah, go ahead.
I'm
What
going
about
to
if I
cut
just
you off
wanted to
because
change a
we're
beneficiary?
just about almost out of time. So I'm going to be putting up on the screen how to get in touch with Camden. So Cindy, you'll be able to do that to get your other questions answered. And Karen, if you have a quick question that you had your hand up.
Oh, I just want to find out. Okay, so we have a home. We inherited my mother-in-law's home after she passed away, and so
Uh-huh.
you said something about you're selling the home that you have in the trust, and that her home's in our trust. So do you have to sell it if it once or can it stay? Or my children would have to like keep it in, create a trust for themselves. How does that work?
I'm sorry, I kind of missed the first part. Is your house in your deceased mother-in-law's trust, or is it in your trust?
It's in our trust.
Okay, gotcha. So yeah, basically it depends if you want to leave the trust assets to your kids outright, or if you're leaving it to your kids in trust. Like, does your trust have a provision that says, upon my and my husband's death, we leave this house to son in trust until he reaches age 40, at which point the trustee gives it to him outright. If you're talking about outright distribution, then no, he doesn't. He would need to create his own trust in order to put it in his trust
Okay.
once it gets into his name.
Okay. All
Yep.
right. That's it.
Right.
Hey, Pauline, this was very informative.
Well,
Great.
good.
I'm glad
Yeah,
it
thank you
helped.
very much. Really appreciate it.
Yeah.
Yeah.
So Camden, just to finish up, if there's one thing that you could leave with people, what would it be?
One thing I would leave with people, I would say that proper planning now is worth its weight in gold later. You will save a ton of time and a ton of money if you do things right now, if you do things correctly now. And so like I would, yeah, just encourage everyone. I don't care if you use me or talk to me, just use a good attorney who you think is going to get the job done, and then just do the shit and keep up to date. It's like it's going to require a little maintenance and tinkering over the years, but it's like the best money you can spend, I would say.
I agree.
Yeah.
I agree.
That's great. Well, thanks, Camden. So to continue the conversation, I offer personal coaching as well as group coaching on retirement. And if you want to book a free discovery call to determine whether the personal coaching or joining a circle is better for you, here's a QR code, or you can go to coachforwomen.com RSVP. And if you want to contact Camden, here's his email address, cd@generations.law. And you can call him at 562-444-8399.
Yeah. Thank you so much, Pauline. And I will say the other thing, if I could leave everyone with one piece of advice, also work with Pauline because she's good. And yeah, I mean, having trusted advisors that you can consult with as part of your team, as part of your family team is super. I mean, I find it great to have that resource, and putting together a team is super important, and Pauline's great. So thanks for having me.
All right. It was a
Pauline,
pleasure.
can you put up Canada's information again?
Sure. go back.
Awesome. And yours, there we go.
There it is.
Great, I got both of them. Thank you so much.
Yes,
Yeah,
thank you.
you're very welcome.
This was excellent. Thank you, Pauline. Thank you, Camden.
Sure
All
thing.
right.
Thank you both.
Pleasure.
Thank you to everybody. Have a very good evening.
Okay,
You too.
Bye.
bye.